Appeals Division 1 is now in session.
Thank you. Be seated. Good morning. Now is the time set for oral argument in cause number 1 CV16 0521. As soon as I get my chair turned around here. The HOPI tribe versus the Arizona SNOWBOWL Resort Limited Partnership. For everybody's information, these proceedings are being both audio and video recorded, so barring any unforeseen problems, you'll be able to critique yourself on YouTube in a couple of weeks. Counsel, each side will be entitled to and allowed the 20 minutes that is standard. We would ask that you respect that time period. The timer located on the podium will let you know how much time you have left. And for the appellant's purposes, if you wish to reserve any portion of your 20 minutes for rebuttal, please let us know. We do tend to ask questions, and make no mistake, we will do so in this case. But we also don't want to take up all your time. So let us know what it is we want to try and reserve. Ultimately, it is your responsibility to reserve that time. We've reviewed the briefs and conference this case this morning, so we are well aware of the facts and issues attendant to this argument. Structure your argument recognizing that to be the case. Counsel, when you come to the podium, I would ask that you state your name and who you represent. And with that, counsel for the appellant, it's your podium.
Thank you, Your Honor. Please the court, counsel Michael Goodstein on behalf of the appellant, HOPI tribe, and I would like to reserve 5 minutes for a rebuttal. Based on the errors of the Superior Court on the motion to dismiss, the HOPI tribe respectfully requests that this court reverse and remand the case for discovery and trial. The HOPI tribe has standing to bring this nuisance claim. The tribe properly alleges a special injury, different in kind from that suffered by the general public.
Now, counsel, you're not asking us to determine today that is that the tribe has standing. You're asking us to reverse a dismissal that was on the basis that they did not allege sufficiently standing.
That's right, Your Honor.
So if we were to give you the relief you're requesting, that would not include a determination that the tribe has standing. Correct?
That's right, Your Honor. We're just seeking a determination that the complaint properly alleges a special injury sufficient to give the tribe standing.
So if we were to accept that argument, you would have to still not only prove the allegations, that is, presumably flesh out the tribe's interests, but also establish that those interests satisfy the standing requirements for this tort.
Yes, Your Honor. We're here today on a motion to dismiss and simply a test of the pleading whether the allegations were properly pled for special injury. And this court can review that de novo, and we're merely seeking a determination that the complaint that the HOPI tribe filed below properly alleges, makes those allegations of a special injury.
Counsel, I understand the fact that you're needing to prove the special injury. We are very sensitive to that issue. What part of the special injury, what part of the damage, if you will, that's being alleged is the fault of Flagstaff? I'm lost as to why Flagstaff is in this lawsuit.
Flagstaff, Your Honor, provides the reclaimed wastewater. It's their obligation under Arizona law. The tribe alleges that they provide reclaimed wastewater that is of a sufficient quality for the secondary user.
Okay,
so
so
they I'm sorry.
Go ahead. Please finish.
They provide the wastewater, Your Honor, and
they provide wastewater that, if it wasn't for the special circumstances of your clients, would not be a problem. Correct?
well, Your Honor, we allege that it's a problem to use this type of reclaimed wastewater in the wilderness area. So
Is the city using the water?
the city is providing it to a secondary user. So they provide it to a golf course, for example,
And
and
would
they
that
have
be a problem, counsel?
no, Your Honor.
Okay, so they could sell that to a golf course and there would be no problem.
Well,
Let me ask you closer to where we are.
sure.
I'm from northern Arizona. They could sell that to an organization that was creating snow in Williams, on the runs in Williams, right? Would that create a problem?
Your Honor, for the Hopi tribe, we have this particular special use of this area. It's the Kachina Peaks Wilderness Area.
Precisely, counsel, but you've altered the circumstance here. My point is, what did Flagstaff do? If they sold it to a golf course, they're golden, right? No problem. If they sold it to a ski resort, such as SNOWBOWL. I didn't mean to say anything ugly for those of you from Flagstaff when I mentioned Sunrise, but I mean, if you understand what I'm saying, if they were spraying this, making artificial snow in Williams, it'd be okay.
Well, Your Honor,
But there's a problem for Flagstaff in that the artificial snow being made is being made on the peaks as opposed to in Williams, and that somehow invalidates Flagstaff's right to do this?
Your Honor, public nuisance, as you know, is based on all the facts and circumstances of the situation. So that, for example, in the Armory Park case, Arizona Supreme Court, the case that sets out public nuisance law in Arizona, that was a soup kitchen. They were providing soup and sandwiches to the homeless, and that use might have been okay in another area, but in that circumstance, in a residential neighborhood, it was found that that was a public nuisance because of the impact.
But it was their conduct that created the public nuisance.
Well,
Flagstaff's just selling recycled wastewater.
well, Your Honor, they're selling it to SNOWBOWL, the secondary user, and they have our position and our allegations is that they have obligations under Arizona law to make sure that secondary user meets the requirements of the water code, which means no runoff from the area, no pooling up in the area, and reasonable activities to prevent human contact. Those are three requirements of the Arizona Water Code that we allege are that SNOWBOWL is in violation of, and that a provider of reclaimed wastewater has obligations to make sure their secondary user meets those obligations of the Water Code.
If I could clarify, while this could have been an alternate grounds for dismissal, this question's not really before us, is it? That is to say,
That's correct, Your Honor.
This kind of thing was raised, I think, below, but not ruled upon by the trial judge and not really briefed before us. Am I
That's
right about
correct.
that?
That's correct. The dismissal was based on the failure to properly allege special injury and
No question, counsel.
the failure to state a claim for public nuisance. So,
I agree.
yes, thank you.
I'm trying to figure out, Flagstaff's going to stand up in a minute, I'm assuming. Someone from Flagstaff's going to stand up.
Yeah.
I want to know what it is they did wrong. Go ahead,
Okay.
counsel.
Thank you. So the Superior Court also abused its discretion in awarding attorney's fees as set out in the tribe's brief because this claim clearly arises under tort and not under contract.
And what was the theory for the fee award?
There is a contract between
But
the
was it
SNOWBOWL and the city.
34101 contract?
Yes, yes, Your Honor. But the tribe is not party to that contract. We're just a bystander to that contract. And our claim arises under tort whether or not there's a contract. It's a public nuisance claim.
On that point, this is a common law tort, correct?
Correct.
So with regard to the Exxon Valdez case from the Ninth Circuit, we're to view a case like that, we're not bound hierarchically to the Ninth Circuit, and we would only follow the Exxon Valdez case to the extent that we find it persuasive. Is that right?
That's correct, Your Honor. You have your state of Arizona nuisance law, public nuisance law, which is applicable to this case.
Well, I mean, if the Ninth Circuit propounds an an opinion with regard to the United States Constitution or federal questions, I assume we're somewhat bound by those, but this is different.
Yes. Exxon Valdez, that was a class action for non-economic damages associated with subsistence fishing.
Because there had been economic damages, but those had already been adjudicated.
Correct. Over $1 billion had been given out in damages by the time the court got to that putative class. So that's a very different case than the case here before you today.
Well, it might have been given a more complete picture of the tribes in that case, what their interest was, if the economic and the cultural interests were being considered together. Instead, there was like, the one was bifurcated out, and they're looking at a fairly narrow description of the cultural interest in subsistence, a subsistence way of earning a life. And
Correct.
It seemed like it kind of abstracted it out.
Correct, Your Honor. It was split up, and there had been economic damages awarded for subsistence fishing. What's really different here than Exxon Valdez is in Alaska, in Prince William Sound, subsistence fishing is something that goes on generally in the public. It's a general type of use, and that's what the court found. Here, the uses that the tribe puts of the Kachina Peaks Wilderness area is special and particular to the tribe and its members. It's not like an average day hike. It is specific cultural and religious uses, pilgrimages, particular ceremonies, particular sacred areas in the wilderness area. That's why it was designated the Kachina Peaks Wilderness Area in recognition of these claims. So in recognition of these uses, and these claims are for the special injury to those particular uses. So you have both of the things you need for public nuisance in this case. You have public rights, which is rights to use a wilderness area for the types of purposes that a wilderness area is designed for, public land, but you also have the special injury, particular uses that the Hopi tribe conducts there, has conducted there for years and years and years, and are now impaired, as alleged in the complaint, by this contaminated wastewater that has, as alleged in the complaint, residual chemicals and different chemicals than in the typical rainwater up there. So
Judge Moran acknowledged the sincerity and the existence of this particular tribal interest, but eventually characterized that as different only in degree from the interest that non-tribal people have in the peaks. Is that
that's correct, Your Honor. The court below, the Superior Court, weighed the evidence on the motion to dismiss, which under Coleman and other authorities is improper. The court has to assume, the trial court has to assume that the allegations in the complaint are true on a motion to dismiss. And the allegations in the complaint set out clearly particular uses of the Hopi tribe. They're not just picking a trail the afternoon that they want to go for a day hike. There are public uses of the area, but there are also particular uses that are specifically impaired. So you have both of the things in this case. The appellee's position is circular, and the trial court's determination was, first of all, prejudging the merits and the evidence, but was also circular. The trial court's reasoning was, if it's a public right, then it can't be a particular special injury. And that's not correct. Under the law of nuisance in Arizona, I'm sorry, Your Honor.
Oh, no, go ahead, finish your thought, please.
Under the law of nuisance in Arizona and under the restatement, you have both of those things in a public nuisance situation. You have a public right that's been impaired, but you also have a plaintiff that has standing because they have a particularized interest, like the Beatty case that the court asked us to address.
That was my question. Go ahead.
All right, Your Honor. This case is similar to those cemetery cases, like the Beatty case, like the Lutherans in Georgetown. The Hopi tribe have a special interest in this area, but they also have special uses that are impaired. So like the Lutherans in Georgetown who were going periodically to the cemetery, there are actual uses that are being impaired in the wilderness area. So it's not just a feeling or a motivation here, as the appellees would characterize it. It's actual special uses, just like the cemetery cases, like the Beatty case, like the Scruggs case out of Alabama, the impairment of the visits, the ceremonies, the pilgrimages, the collections of special materials. That's what's alleged in the complaint, which forms the particularized injury here. But there's also, because it's on public land, there's general use and general public interest in maintaining the pristine nature of the wilderness area. The court below also erred by not allowing the tribe an opportunity to amend its complaint. And there was a motion to amend filed below and a proposed amended complaint, which the court did look at, but that was before the ruling on the motion to dismiss. So when the tribe moved for reconsideration and requested an opportunity to amend to try and meet the heightened requirements of the court below, the court did not give the tribe an opportunity to amend. There are affidavits in the record that show that we could provide even more detailed allegations about impairment of these uses. So there are a proffer below which shows that had the tribe been given an opportunity to amend, they could have provided even more specific detail about how individual users and individual kivas were obstructed and impaired in their traditional uses of the area.
Counsel, is that a Rule 12 assist, or is that a Rule 56 component?
What it is, Your Honor, is we're appealing the court's determination of futility, right? So the court, in misinterpretation of the law, also made a determination that it would be futile for the tribe to amend. Now, we moved for reconsideration on that. The court reaffirmed its ruling of futility so that there was no opportunity for the tribe to amend. I'd like to reserve the rest of my time for rebuttal.
Thank you, counsel.
May it please the court, my name is John Egbert. I represent the Arizona SNOWBOWL Resort Limited Partnership. By agreement with Mr. Kleekan, my intention is to reserve the last 5 minutes for him to address some of the specific Flagstaff attorney fee issues. I'm going to start with where the court started in questioning in terms of what was the nature of this motion and what was the nature of the court's ruling below. Our position is that the motion was not merely a pleading defect motion. It was a 12b6 motion for failure to state a claim, and the additional ones that the court didn't reach, I'm not going to address, but the specific one the court did address was that the HOPI tribe was unable to state a claim for public nuisance because it in fact does not have a special injury. This wasn't a situation, and I would cite to Index of Record item 149, where the court's conclusion is the court grants third-party defendant SNOWBOWL's motion to dismiss per Rule 12b6 for failure to satisfy the standing requirement to show that plaintiff has suffered a special injury as required to maintain an action for public nuisance. That's what the court did. It wasn't simply saying that this particular draft of your complaint fails to state an element, and therefore, you need to, under those circumstances, what trial courts typically do is then give leave to amend.
But counsel, isn't Beatty directly on that issue? as to whether or not religious issues, the sanctity of the cemetery, isn't that effectively a parallel to what the HOPI are arguing here?
Not at all, Your Honor. Beatty was not a public nuisance. There was no claim for public nuisance asserted by the parties in the Beatty case. There was a claim for specific performance of an alleged contract, which the court below rejected. And then there was a request to quiet title, or not quiet title, quiet their possession or use of this particular lot by the church. And there was no claim for public nuisance. Now, the court admittedly clearly did use the term public nuisance, but we would submit that because there wasn't a public nuisance claim where the court was now analyzing, okay, do they have standing under the public nuisance in order to assert that claim, and is there special injury, that what it said, the use of that term was dicta. But even if it wasn't, the main holding of that case was that there was, in fact, some property interest possessed by the Lutheran Church. So they had some sticks out of that bundle of property rights that they held, even though it was kind of squirrely and it had to be done in a court of equity rather than a court of law. But that easily fits within the well-established special injury category that exists when somebody's right in property, use and enjoyment of property, is interfered with. So even if, and I don't think that it was the public nuisance case at all, but even if we were to view it because of the language that the court used, that's easily explainable in terms of the plaintiffs having the ability to pursue such a claim because of their property interests, which is what the court's primary holding was.
Counsel, shouldn't we be concerned about Judge Moran's use of the word, or use of the word show in granting this dismissal? That is, granting the dismissal because the tribe failed to show that they had a special interest. They didn't have to show anything at the Rule 12 stage, right? Simply to allege what's necessary.
Well, they had to allege a special injury. They had to demonstrate at some level that they could state a claim. And part of state...
Isn't that the job of summary judgment? At the point of the Rule 12 motion, all they do is state facts that, if proved, would establish the requisite standing.
But Your Honor, if somebody comes in and says, states facts, and they say, we admit we don't have any special injury, they've stated facts, but they've also torpedoed they can't state a claim for public nuisance. And so here the trial court went well beyond saying this particular complaint has a defect in terms of what you've alleged. The court held you do not have a special injury because...
How could the trial court know that until you get to the appropriate time for determining the merits of the allegations?
Because in order for a private individual to assert a public nuisance claim, they have to allege that they fit within some sort of an exception that allows them to get into court.
But at the 12B stage, they don't have to prove that, and this is what Judge Thompson's getting to. They don't have to prove that. They simply have to assert that.
That's right. And they didn't assert our position, and we believe what the trial court found was they did not assert anything that fits within any of the recognized categories for special injury.
So the religious practices, a.k.a. a cemetery, don't apply. Their time valued, or time, and I don't want to say value in the legal sense, but their interest in the pristine nature of the environment that may later be proven to be being violated by this water, the assertion of that was insufficient?
It is, Your Honor, because if you look at Prosser's article where, well, take a big step back to 1536, which is the year that Professor Prosser says was the first time ever that a public nuisance claim was allowed to be brought by a private individual. That was when the first time, prior to that, it was the sovereign, the king, the sovereign, or his or her public officials that had to bring this criminal case against whoever was creating the public nuisance. During that 400-plus year period after that 1536 decision, there had never been a claim asserted for public nuisance in which somebody was able to, a private individual was able to do that based on the fact that their religious sensibilities would be offended, or cultural sensibilities, whatever you want, would be offended because of the use of public land. And there are four and Prosser outlines them and talks about them, categorizes all these years of decades, centuries of common law, categorizes them, and none of those categories comes close to saying religious or cultural sensibilities is good enough. And there's good reasons for that. If you think about what the reason for the law in the first place is that we don't want to, first of all, have 1,000 different lawsuits whenever there's a highway blocked, a public road blocked. And we also think the start of it was, that's the sovereign's prerogative or the sovereign's representatives to bring that kind of an action. And so, admittedly, there were some few very narrow exceptions that started to be developed, but our case doesn't even come close to fitting within any of those, because here's why. This is not a situation where, for example, the classic public nuisance is a public highway that gets blocked, and there's a bunch of people who want to use the public highway. Most of those people don't have standing. The case law is very well developed in this area that says, look, if you have some real property that is blocked, you can't get to it because of that special injury. If you have a pecuniary loss because you can't get your contract fulfilled because of the block, you have special injury. But if you want to, and the restatement comments talk about this specifically, that if you want to use the road because you want to go shopping, that's not different in kind from somebody who wants to use it to go to church. Those are just reasons why people want to use it. We submit that that's what's happening here. We have a pristine wilderness area that the HOPI tribe very, very appropriately and correctly says we've used that for a long time and for reasons that are very important to us. But that's not different from the environmentalists who want to use it for other reasons, or the recreationalists who want to use it for other reasons still. So here's the kicker. If what really happened here was that SNOWBOWL went to the sovereign and said, we would like permission to block this highway. And the sovereign analyzed it. Is this a good thing, a bad thing? Weighed all kinds of competing interests, including the HOPI tribe and everybody else's interests, and said, we're going to grant you permission. We approve you blocking this highway. And they went forward. That's not a situation where we ought to be recognizing a special injury where somebody gets to come in. This is not a situation where the public officials failed to abate a public nuisance, and so we ought to let somebody else who has a special harm come in and fill that void. This is a situation where the public officials actually addressed the issue and approved it, did not merely fail to abate it, but actually approved it and permitted it. And that's not a case where we ought to be recognizing a new category of special injury to allow somebody to come in after all that process has gone forward. And by the way, when I say that it's been approved, it's not just, it's the federal and state level both. We have the Arizona Department of of Environmental Quality, which said A+ reclaimed water, which is what's at play here, is appropriate for snowmaking. So it went through a public process and made that determination. And then even more so, we've got the U.S. Forest Service, who is the effective owner or the representative of the sovereign who owns the land, and they went through a years-long process. And everybody had an opportunity to participate in that, including the HOPI tribe, and they did vigorously.
That will all come out, counsel, either at a Rule 56 stage or in the course of trial when you're putting on your fact witnesses, correct?
Well, Your Honor,
does that preclude the complaint itself at this time?
it should, because there is, in order to get to the point of even stating a claim upon which relief can be granted, the classic 12b6 standard, you have to be able to show that we're not in the category. Yes, we're private individuals, but we're in this special category because we fit within one of these recognized exceptions. Well, they don't. And their allegations don't, no matter how they've alleged them in their complaint, and even how they've kind of recharacterized or recast them in their motion papers to try to kind of expand them, and even as they've addressed them in their proposed amended complaint, which was denied, all of the above, none of them address this situation or fit within an exception that would allow them to state a claim. There's no reason to go forward and have a summary judgment motion here because their allegations, no matter when they say them or if we do it in the context of Rule 56, is going to carry the day.
Well, their allegations aren't going to carry the day at summary judgment. They have to have proof.
No, yeah, and Your Honor,
but you keep saying that they have to show it at the time of the Rule 12, and all they have to do is say it.
Well, but they didn't say it. They didn't say that.
That's the issue.
Yeah,
I agree.
And that's what Judge Moran held, that, look, you did not get yourself by your own allegations. And he said in his order, he said, I'm accepting, I have to accept all their allegations as true. That's appropriate. He had to do that. But what he's in effect saying, even when I accept those allegations, and by the way, even when I accept the proposed amended complaint allegations, you haven't stated a claim because you do not fit within, even under those allegations, a recognized exception to that rule that you have to have special harm. And there's very strong public policy reasons why this court or Judge Moran or anyone else shouldn't be recognizing that an additional category of special harm that's for religious sensibilities. If we're going to recognize that, then are we also going to recognize that those that feel strongly about environmental protection, that's reason enough, that's different in kind?
But wouldn't that be? Wouldn't someone's religious inclinations or persuasions be different in kind from someone's environmental interests?
No, Your Honor, because it's exactly the situation that the restatement addresses, that if I'm trying to use that blocked highway to get to work, I'm trying to use it to get to school, to work, to shop at the mall, to go to church, those are all motivations for me using it. The harm is the same for all of us. We can't use the highway. The reasons why we want to use the highway are not an injury that's different in kind. That's a different reason or motivation to use it. What's happening here is that the Hopi tribe wants to use it for a different reason. No doubt about it. We don't question that. But the environmentalists want to use it for a different reason. The hikers want to use it for a different reason. And if we start saying any reason why you want to use the blocked highway or the pristine wilderness area, any reason that you want to do that is a different injury, different in kind injury, then, the limited categories are now expanded to, and I mean, we're talking about 400 years worth of history where we've been very narrow in allowing this to happen. And I go back to my point that this is particularly important where the public officials who are the ones that the whole thing we're supposed to have public nuisance addressed by them, they have addressed it here. They have not simply stood on the sidelines and now we ought to think about letting someone with special injury come in to protect their own interests. They have addressed it and they specifically approved it on behalf of the sovereign whose land it is. And so we submit that this decision should be affirmed. There's no need to go back and have a summary judgment on claims where they're just simply not going to be able to assert a cause of action for public nuisance based on the facts as they have alleged them or discussed them. I do want to leave some time for coapoly, so we would request that the judgment be affirmed.
Thank you, counsel. Counsel, you have 3 minutes and 40 seconds.
Don't tell a lawyer he has 3 hours. He'll use it.
What he do quickly.
Understood. My name is Jack Cleakin, Your Honor, on behalf of the City of Flagstaff. I was primarily here to address the attorney fee issue because it seemed to me it was our attorney fee application might have been a little convoluted, and I was going to try to clarify that if you had questions about it.
Address the issue why Flagstaff's in this case.
Well, we didn't raise it at.
Briefly, by the way.
Sure.
Briefly.
I have no idea. We didn't do cause a nuisance. The city of Flagstaff, as has been alluded to, went through a whole process about approving the contract and monitoring contract and extending the contract. And steps along the way involve input from all over the community. And so we concur that this is not appropriate public nuisance claim because public nuisance wasn't intended that way. It was originally intended to be addressed by the legislature or the governing body.
Well, in fact, you brought SNOWBOWL into this case, didn't you?
We did, yes, because we have a contract with SNOWBOWL, and SNOWBOWL was alleged. We agree with SNOWBOWL's argument that the injury is common to various groups. The injury, the nuisance injury, is the damage to the area. Now, how that affects different people doesn't create special injury. The injury is the same. It may be differently applied to hikers versus to the HOPI, but it's still the same injury, and that's I think what Judge Moran was getting at. So
You might want to jump to your attorney's fees.
I will. I see less than 2 minutes, and I don't need to say much about it. We think that actually, Your Honors have multiple decisions. I looked it up, and I think, Judge Thompson, you have over 80 decisions, and Judge Jones, you have over 20 decisions dealing with 34101, and have consistently applied the but-for test. In fact, I think stated one way.
Every once in a while, the Supreme Court surprises us.
Yeah, understood. But what happened with the attorney's fees was in the original appeal, the attorney's fees were awarded, but because your court did not reach a couple of the issues, it was remanded for recalculation of fees. We did the recalculation, and Judge Moran awarded $146,000 in attorney's fees based upon the original complaint that included an illegal contract. So I don't.
Something about fees in the first appeal?
Yes, you did.
Did we?
Yeah, you remanded it to recalculate the fees because part of the fee work was for the water law litigation.
But was there a question raised as to the propriety of
Yes.
fees at all?
Oh, yes. Oh, yes. And that part was affirmed. It was affirmed and for recalculation. And since it came back, it was coming back to the court, we did that recalculation here. So our position is that Judge Moran did exactly what Your Honors have directed or said should have been done, and that's look to see what was said in the complaint and whether that constitutes a special injury. We believe it does not, and would ask the court to affirm.
Thanks, Counsel. Counsel, you've reserved 4 minutes, and I'm not exactly sure what you want to do.
Well, I'd like to make you take some of the time to answer the question I have. Because it seems to me that the appellees have properly identified some good reasons for why we have the standing requirement. And they've pointed to the fact that this issue has been addressed, including the HOPI concerns, by our bodies of public governance who are democratically appointed. And the problem with just allowing anybody to come into court and complain about government decisions is that it kind of subverts our democracy, right? And I think you have to agree with all that.
Yes, Your Honor.
So, and the question is the particular interest that the HOPIs have expressed and alleged, is it different in kind from? I mean, I live in Flagstaff. I live down the street from SNOWBOWL and in the view of the peaks. And to me, the peaks are a very important part of my life, and that's true of a lot of people in Flagstaff. But I have to understand, because I live there and I hear things, that the HOPIs have expressed that they have a different interest in those same peaks than I might have. And so the question here is, has the trial court cut off your opportunity to explain why your clients have a special interest. We're not in a position, because there's a lot of talk here today about what the HOPI's interest is and whether it constitutes a peculiar enough interest to get past the standing threshold. And yet, until it's developed, I don't know what it is. And when Judge Moran used the words, the tribe has failed to show that they have this, that causes me some concern. So I think that puts the issue, there's a legitimate interest in requiring a solid showing of standing before we let small parts of our citizenry dictate what our public policy should be. On the other hand, the law does allow them a chance to attempt to show that.
Counsel, we're going to give you 3 minutes from now.
All righty.
Let you go ahead and answer your
Thank you,
address
Your
your
Honor.
issues.
Thank you, Your Honor. And the tribe has made the proper allegations, and there's been a weighing of the merits below improperly at the 12B stage. There has been an argument of the merits today improperly at the 12B stage, and this court de novo reviewing the allegations.
Ultimately, it'll be a trial judge decision about standing. Is that right?
That's correct, Your Honor.
I assume you would get a jury trial ultimately on the rest of it, but standing
Yes.
will be determined by the judge.
Yes, Your Honor. And it's worth pointing out that Exxon Valdez case that the court relied on below, that was a summary judgment decision. That's where that was considered there. So this was a...
Fortunately, in that case, what they said was that the issue raised by the Indians, I believe, in that case, was the same economic concern that was raised in the economic settlement. Is that not correct?
Yes. Subsistence fishing was determined by that court, and if you read the trial court decision in that case, it's very instructive.
So
because
they
the
were
court,
both economic interest, is what they said.
and they were the same, yes, and they were the same activities, subsistence fishing. What we're talking about here in our allegations is specific types of uses that are particular to the tribe. The ceremonial uses, the pilgrimages, and the collection of material for religious purposes, including water. Those allegations in the complaint show that the tribe has a special interest in use of the area that is not shared by the rest of the public.
Could you
It's particular
respond
to the tribe.
Argument that how does this differ from, say, an environmental or a hiking group that has, say, a long history or a particular interest in these peaks, and they use the land and they go there, and they perhaps it's not religious in a traditional sense, but for a lot of environmentalist interest groups, it's akin to a religious interest. So how would you distinguish that, or would you say that they also have a special injury in this
Well,
case?
Your Honor, that's the public part of it, and they wouldn't necessarily have a special injury the way the tribe does. If their experience is fungible, if they can go on their day hike to another area and essentially have the same valuable experience, then that would be like the highway users, that everyday users don't have a special interest, but people who are on that highway to go to the cemetery, to go to a sacred place, like the tribes are going to specific sacred places right around the SNOWBOWL area for their ceremonies and pilgrimages. Here you have both, like you have in the cemetery cases. You have an impairment of a public interest, the use of the wilderness area, but you also have this impairment of special particular uses for the tribe. And the tribe here should have standing, just like the neighborhood association had standing in Armory Park. So it's very efficient for standing purposes, for the allegations to be accepted as true and for the tribe to be given standing, because it's their individual members that have these special uses, that go on these pilgrimages and that have ceremonies in the sacred places right around the SNOWBOWL area. So it's an appropriate party to bring this case, the tribe, because its members, just like the members of the Armory Park Neighborhood Association, have the impairment. And just to wrap this up, Your Honors, This use is an extremely valuable use. These special uses that are alleged in the complaint, because they are based on cultural and religious connections to these specific areas, they're very high value uses. And the court below needs to be given a full evidentiary record and taking the opportunity to weigh the evidence like you do in a public nuisance case and weigh the impairment of these very special, very valuable uses with the very small economic benefits associated with this reclaimed water use on the peaks. So that weighing of the evidence needs to be done on a full record, and it was done prematurely here. And because of that, we asked that the court reverse based on this error, based on the fact that the complaint properly states a claim and standing, and also because the court prejudged the evidence at the 12B6 stage.
I probably should caution you that we will not be determining this based on our evaluation of the economic value of this activity to the SNOWBOWL or to the Flagstaff area, because obviously that's beyond what we're asked to decide here.
But that's what we alleged in the complaint, was that those interests need to be evaluated, because we think that when fully weighed, the court will.
Because I have to tell you, most people in Flagstaff would say HOPI interests are valuable, SNOWBOWL and economic activity is valuable. How that shakes out, I don't know.
It should just be determined on a complete record, Your Honor. Thank you very much
counsel.
for your time.
I hope you can appreciate the fact that we were very interested in this oral argument today. We appreciate your preparing yourselves in the way you have and your time you've spent with us. We're going to take this matter under advisement at this time. We will rule in due course, and we are adjourned. Thank you.
Sir, sign up sheet?
Yeah, that's right.
You want it?